So guys, very good morning, and we have in our class now Gaurav Agarwal, Gautam, Harshit, Hemant Kumar, Kartik Rajput, Mukul Swami, Prakash Chaudhary, Pushpender, Rahul Jevaria, Rakesh Raika, Ravi Raman, Rohan Modi, Rohan Pingle, Shaurya Dikshit, Soumya Deepa. Soumya Deepa, I think this is your first class. You are most welcome. And Tirthak,
Thank you, sir.
yeah. So who will tell me what we have done till date amongst you? Gaurav Agarwal, will you be able to tell what we studied in the last class? It was regarding consideration. Hope you remember that. So now we will be from today and onwards. What we will be studying is, let me just show you your course pack, where we are now and what we will be studying today and how we will be taking it further. So here we go. So presently we are here. So though it is a 8th or 9th class, but still we have to do this. So we will be doing it today and taking it further. Okay. So the consideration is already done. The capacity to contract is remaining. So we will do this. So we are a little bit lagging behind, but for sure we will be, now doing it. Okay, just let me just start the class without wasting much time. Yeah, so today's topic, what we will be going to study is free consent. Okay, sorry, not free consent. This will be uh, your capacity to contract. Free consent will come afterwards. So today we will be going with capacity to contract, or you can say contractual capacity. Okay. Speed over here in the university is little bit less. So no problem. Okay. So in the contractual capacity to contract, what does it means? In law, persons are either natural or artificial. So natural persons are human beings and artificial persons are corporations. So contractual capacity or capacity in an is an is an incident of personality. Means if you are a person, then you are capable of doing certain, so that what is called capacity. So section 11 provides that every person is competent to contract who is at the age of majority according to the law to which he is subject, and who is of sound mind and not disqualified from the contracting by any law which is to which he is subjected to. So here this definition is talking about three things. So first most thing is that he must be a major, he must be attain majority. Second is he must be of sound mind, and further he should not be a disqualified person, or you can say a person who is disqualified from law for making any contract. So a valid contract requires both the parties should understand the legal implications of their conduct. Thus, both must have a mature mindset. Okay, so why it is needed? Why we are saying that there has to be a capacity to contract? Because both the persons should be at least be able to understand their good while entering into a contract. Otherwise, what will happen? If these persons like minors, or you can say the people of unsound mind, so the other person who is of the sound mind will be having a undue advantage of them, and will just make an unjust enrichment out of them, which will be against the law of natural justice. So in order to ensure the law of natural justice, a valid agreement must be between the two parties who are actually able to understand the legal implications of the contract which they are actually going to make. Okay, so that's why it is so. So I have told you that there are three type of persons. One are major, means majority is one of the aspect. Second aspect is your that a person should be of sound mind, and third is that he should not be disqualified. So these things we will be studying one by one. So therefore, the general rule is that a natural person who have the capacity to make binding contract, except minors, lunatics, and person disqualified from contracting by any law to which they are subject to. So these are the three people whom we will be discussing now and onwards. So the legal yardstick to measure the majority according to the law of contract is that both must be major and of sound mind, and if not, the law would presume that the maturity of their mind has not reached to the extent of visualizing the pros and cons of the acts which they are doing. So they may be because one must understand the things. So one must understand the pros and cons. One must understand that what will be the consequences of their conduct with this particular thing. So that's why it is. So first of all, let us take the agreement with the minor. So according to Indian Majority Act 1875, a minor is a person, male or female, who has not completed the age of 18. A person who is not completed the age of 18 is not eligible to make a contract. In this case, in case a guardian has been appointed to minor. Now this is another feature. So we have the two majority ages. One is age of 18 years and another is age of 21 years. Suppose, for example, a guardian has been appointed to minor, where the minor is under the guardianship of the court of wards. The person continues to be a minor until he completes the age of 21. So if the court has appointed some person as a guardian to him under the court of wards, then that particular person must attain the age of 21 in order to be a major, or in order to attain the majority. So let me just take you to the movies, because you also watch movies and I am also fond of. So you might have seen a movie called Satte Pe Satta. It's a Amitabh Bachchan double role movie, where the girl in question was actually having appointed wards, and those wards have actually wanted to kill that girl before attaining her majority, because afterwards, if there is no person to whom the property is to be transferred, so that person who is a trustee of the property will become the owner of that property. So that trustee actually tries to kill the girl, and Amitabh Bachchan and all, they tried to save her till end. So this was the story in that. So what I want to say is that the girl also had to attain a age of 21. So she doesn't becomes major at the age of 18, but she has to attain the age of 21 in order to become the major. So according to the Indian Contract Act, no person is competent to enter into a contract who is not at the age of majority. It was finally laid down by the Privy Council in the leading case of Mori BB versus Dharmodas Ghosh. The minor has no capacity to contract, and the minor contract is absolutely void. This thing was decided in this particular case. So what were the you can say the facts of the cases were, in this case X, a minor, borrowed rupees 20,000 from Y, a money lender. As a security of the money advance, X executed a mortgage in favor of Y. So who was X? X was a major. X was a minor who actually borrowed 20,000 rupees from Y and executed a mortgage in favor of Y. And when sued by Y, the court held that the contract by X was void and he cannot be compelled to repay the amount advanced to him. So in this case, whosoever will enter into a contract with the minor, he has to face the circumstances. He has to face the consequences. It means one must beware while entering into a contract with a minor. So who will be in the advantage position? The minor will be in the advantage position in any of the ways. So here even the mortgage was executed, but the mortgage was also released because the contract is totally void. So X property which was mortgage was also came back to him, and this 20,000 rupees which was taken was also not at all. And 20,000 in 1903, you can imagine it is more than 2 crores of the present time. So just imagine what would have happened. So, and it was decided that the contract will be void because it has been between the major and the minor, and minor will be having advantage of the same, right? So Indian courts have applied this decision to those cases where the minor has incurred a liability, or where the liabilities on both the sides are outstanding. Okay, so in such cases minor is not liable, but if the minor has carried out his part of performance, then court have held that he can be proceeded against the he can proceed against the other party. For example, in such a case where there are two parties and minor has actually executed certain part of his contract, so the court will compel the other party to execute the part of the other company. It means that ultimately what the thing will happen, the minor will get the advantage of the thing. He will get his things done either by himself or through the court. So rationale to protect the minor, the rationale to protect the minor interest is that according to Transfer of Property Act, minor cannot transfer a property, but he can be a transferee, a person who can accept the transfer. So this is a statutory provision in an illustration of the above principle which is there. So following points must be kept in mind in order to in respect of the minors agreement. First of all, the minors contract is altogether void in the law, and minor cannot bind himself by a contract. Even if he himself says, okay, I would like to bind myself with the contract, that too is not possible. If the minor has obtained any benefit, such money on a mortgage, such as money on a mortgage as in the case of Mori Bibi versus Dharmandas Ghosh case, he cannot be asked to repay, nor can his mortgage property be liable to pay. It means the property which he is mortgage is also free from any mortgage also. So since the contract is void ab initio means it is void since beginning. So it cannot be ratified by the minor even on the attaining the majority. For example, the minor has entered into a contract with the major, and there was no dispute. No dispute has happened during the period till he has become major. And after becoming major, if he wants to ratify the contract, means if he wants to say that the contract which I did before at the age of minority may please be ratified, or the law may consider that contract as a valid one, that is also not possible. So after, in such a case, what will happen after attaining the majority, the minor has to enter into a contract again, and it will be applicable from the date of entering into a contract by him after attaining the age of majority only. That is there. So estoppel is an important principle of law of evidence. So to explain, suppose X makes a statement to Y and intends that the latter should believe and act upon it. Later on, X can resile from the statement and make a new one. For example, if X is a minor and X befool other and says that I am a major and I want to enter into a contract, and the other has believed it and has entered into a contract, and later on X can again say, or you cannot stop X to say that you cannot take your contract, you take your words back. So in that case also X will be held responsible as such for the contract. Okay, so in other words, X will be stopped from denying his previous statement, but minor can always plead the minority as and not the as if not stopped. Okay, so it will again be the you can say the liability of a person who is actually entering into a contract, that he has to fulfill his part, and you cannot stop the minor also by denying the fact that he has done it. Okay, so he has produced a loan and entered into some other contract by falsely representing that he was a major and committed to contract when the reality he was a minor. Then also the law will protect him only. So one or the other way, minor will be protected, and the principle of estoppel will not be applicable over here. But where a loan was obtained by fraudulent representation by a minor, or some property was sold by him and the transaction are set aside being void, the court may direct the minor to restore the property to the other party. So one more important thing is there, he cannot just enjoy all the benefits in which is in front of him. Suppose, for example, he has purchased one property by misrepresenting his age, and then afterwards he is having the hold of that property, and if the court finds it that okay, the property is it doesn't belongs to him and it belongs to someone else, so what the court can do, it can actually restore the property which he has to the other person, okay, to whom the property actually belonged. So that is what the court can do. Means Just like a kid, if he has taken something from someone, if a kid has taken something from someone by misrepresentation or something like that, then the kid is also told that okay, bache, now just give it back to the uncle. So something like that. So it has to be returned back by the kid, and the parents in that case will ensure that the things are returned back to the other person whom actually it actually belongs to. In the same way, the court also does. The court also consider minor as a kid only, and it will just tell him to just give back the property, and the property will be restored in the name of some other person itself. Okay. So this is something related to that only. A minor fraudulently overstates his age and takes the delivery of a motor car after executing a promissory note in the favor of a trader for its price. So minor cannot be compelled to pay the amount of the promissory note, but the court on equitable ground may order the minor to return the car of the trader if it is still with the minor. Or suppose, for example, if the car gets accidented, so minor cannot be held responsible for such accident also. And even if the minor has sold the car and has embezzled the money, and he has actually done with the money, or he has actually utilized the money somewhere else, so the money cannot be recovered from him in that case. So the property or the money whatsoever minor is having can be recovered only if the minor is having the custody of that property or the money. If he is having, then it can be restored, otherwise not. So according to section 33 of the Specific Relief Act 1963, the court may, if the minor has received any benefit under the agreement from the other party, require him to restore so far as may be such benefit to the other party, to extent to which he, she, or his state has been benefited thereby. Okay, so this is a case, means to the extent it is recoverable, it will be recoverable. To the extent it is not recoverable, the other person who has entered into the contract with the minor has to forego that particular property for which he has entered. Further, a minor state is liable to pay a reasonable price of the necessities supplied to him or to anyone whom the minor is bound to support. However, minor is not liable personally, such as such contracts are considered to be a quasi contract. Now, in such case, if you have helped some minor, for example, minor is in need of your help. Suppose he has met an accident. So, in case of an accident, minors might be needing your help. In such a case, if you help the minor, then in that case what will happen? The minor's property will be responsible to pay you back the amount for which you have actually entered. This is actually a quasi contract, which I told you that voluntary contract happens. Sometimes you find a purse somewhere and that purse doesn't belong to you. You have to search the owner of the purse and you have to give that purse back to him, and you can charge whatever reasonable amount is to be charged from him for finding the true owner. In the same way, this is also a quasi contract that you have helped the minor, and in that case all the necessities which you have supplied to him, okay, and in that case whatever necessities you have supplied, you are entitled to charge either from him or from his property. But the thing should be necessary, means it should be a necessity. For example, you find some minor somewhere and you asked him to just go at home, or he might have left home, or you are trying to just send him home, and you have booked a plane ticket. So plane ticket will be a luxury, not in a responsibility. Now here, if you have booked a plane ticket, you cannot get it from him. But yeah, for the bus ticket or for the train ticket, which is a reasonable responsibility or reasonable price of the necessity which you are providing him, you are entitled for that. So in that case, it will be applicable. So necessity supplied must be according to the position and the status of the life of the minor, and must be the things which the minor actually needs. Following have also been held as necessity in India: cost incurred in successfully defending a suit on behalf of the minor in which the property was in jeopardy, cost incurred in defending him in a prosecution, and money advanced to a Hindu minor to meet his marriage expenses have also been held to be necessities in India. So this marriage case is now not applicable, because previously minor's marriage was allowed. Now the minor's marriage is not allowed. So any amount you have spent for the minor's marriage will not be recoverable, because it is not necessary. Rather, it is against the law. So in such a case, whatever you have paid on the behalf of a minor, even for defending him from a suit or a cost incurred for his prosecution or whatsoever, so these all will be the necessities which you have provided to the minor, and accordingly you will be able to recover if the things have been incurred by you. Okay. Next is agreement by a minor being void. The court will never direct the specific performance of the contract. So as the contract with the minor is void, now the court will cannot ask for the specific performance of the contract by the minor. For example, a minor has entered into a contract with other because he is a very good painter to paint his picture. So now and after taking the advance money, minor can refuse. I will not go for this painting, and the money which he has taken has also been utilized. So in this case, the specific performance of the contract cannot be enforced. Specific performance means the minor cannot be compelled to draw a picture or a sketch of someone with from whom he has taken money. So in that case, the minor as the minor contract is void, he cannot be directed for the specific performance. Next is the minor can be agent, but he cannot be a principal, nor can he be a partner. He can, however, be admitted to the benefits of the partnership, but he cannot be actually partner. So this will come in your partnership act also. Can minor be a partner? So yes, minor can only be admitted to the benefits of the partnership. In that case, whatever profit has occurred in the partnership, you can share the profit. But if in case of losses, minor's property and minor will not be responsible for any losses. In the same way, minor can be an agent, but he cannot be a principal. For example, because for all the acts of the agent, principals are responsible. So it's upon principal. If he wants to make minor as his agent, then the total risk is on the principal itself. But a minor cannot be a principal. For example, let me just give you an example, implied example of, or you can say example of implied agency. Suppose, for example, near your we used to take groceries from the grocery shop. So what happens if we are taking a grocery and we are sending our minor son to just take some grocery get some grocery from the grocery shop, and which actually is to be the dues are actually is to be cleared at the end of the month, and the minor has taken something which otherwise is not at all, you can say, or otherwise it is very expensive from the grocer, and grocer in the belief that you will be paying the money has given something to the minor. So in that case, you being a principal will be held responsible for the acts of the minor, and you have to pay for it. So this is something which is related to a minor's case. Next is, since a minor is never personally liable, it cannot be adjudged as insolvent, because insolvency of minor is not at all a question, because he himself is not at all responsible. So a person who is not responsible cannot be adjudged as insolvent. Next is an agreement by a parent or a guardian entered into on the behalf of minor is binding upon him, provided it is for his benefit or for the legal necessity. So any contract which is being entered by the person, means by the major or his parents or his guardian for his benefit, will bind the minor for his benefit only, and it is a legal necessity, then it has to be done. So for the guardian of a minor may enter into a contract of marriage on behalf of the minor, and such contract would be good in law, and the action for its breach would lie if the contract is for the benefit of the minor. So there is a case of Rose Fernandez versus Joseph Gonzalez. So this is again a very old case. In this, what happened, if the example, if the parties are of the community among whom it is customary for the parents to enter into a contract for the marriage, the contract of the apprenticeship is also binding, or means this is a contract of apprenticeship is another example. Okay, so that is also equally binding, and the contract of marriage, if it is customary, then it is done for the benefit of the minor, will be binding on the minor. But I have told you before also, the contract of marriages these days are not at all applicable for minors, because the minor's marriage itself is against the law. So one should not do anything which is against the law. So the act inter alia provides that the minor must not be less than 14 years of age and the contract must be entered into by the minor's guardian. So this was something before the passing of this Hindu Marriage Act, which has actually allowed the people, to those who are above 18 years, to go for marriage. So however, it has been held that an agreement for service entered into by a father on the behalf of his daughter who is a minor is not enforceable by law. So this is very good case, that Raj Rani versus Prem Adib. So this is 1948 case where a father has entered into a contract on behalf of the service to be rendered by a minor. I have told you that case of making a picture or a photograph, something artistic work which is to be done by the daughter. So in that case also the minor will not be held responsible for the specific performance of the contract. So this is all about minor. So please ask if you are having any problem in this, or if you have some discussion to do. Yes. Anyone? Ravi Ravan, Shaurya, any problem or any confusion up till now?
So
Want
why
to ask?
No,
guardians
sir.
are not held liable for any problems caused by minors?
Sorry?
Why guardians are not held liable for any problems caused by minors during a contract or anything?
Problems caused by minors.
Like if suppose in a contract you said that minors are not held liable for any losses, but they are held, but they're given equal share for the profit. Uh, but why guardians are not held liable for losses in a contract?
See, if what happens, guardians and parents are not responsible for the act of the minors. As I have told you that this is when we are talking of a contract, then this is something which is which might be done on their behalf. Somebody else has done it. Okay, because it's a minor, you cannot compel minor for anything, right? So when we cannot compel minor for anything, so he cannot be responsible for anything also at the same time. So that is the main principle behind it, because the contract with minors is void, as I have already told you. So anything which a minor, so actually what the thing is, they are at their wish. So the law and the this act also considers that minors are someone, those who are actually, this is their time and this is their age to enjoy the things and do the things by their own. And even because they are not at all aware of what is going on in the world of in this you can say the world of the world which is actually uh, you can say the harsh world which they have never been exposed of. So they are protected against everyone else in the world. So that's why these things are applicable. Hope it makes sense.
Yes, sir.
Yeah. Anyone, anything else if you want to discuss, please tell. So should I proceed further now? Yeah.
Yes.
So let us go further. So next is your you can say the agreement with the person who is of unsound mind. So for the purpose of making the contract, a person is of unsound mind if at the time when he makes the contract he is incapable of understanding it and of forming a rational judgment as to effect upon his interest. Now, a people of unsound mind are considered because they do not have a sound mind. They cannot think properly and they cannot think of their own good. So, any contract which is made by such person will result in undue advantage being taken up by the other person who is entering into a contract with him. So, a person of unsound mind cannot enter into a contract. A lunatic, he is called lunatic. A lunatic agreement is therefore void. But if he makes a contract when he is of sound mind, during the lucid intervals, he may be bound by it. For example, a drunkard who actually drinks, so he drinks the daru, and after drinking daru, he is actually of unsound mind, and during that period, if you enter into a contract with him, he cannot be held responsible if he is having a reason to believe that he was not in his senses when this contract was made. So so a sane man who is delirious from fever or who is also drunk, that he cannot understand the terms of the contract or form a rational judgment as to effect for his own interest and cannot contract while as such delirium or state of drunkardness last. So after being coming out of this drunkardness, he can also he can enter into a contract with others. So you cannot enter into a contract with any bevada when he is actually fully tully. Okay. So at that time you cannot, because at that time he is actually not at all able to understand. You can make fun of him at the time, but you cannot enter into a contract because a person is having a mental decay, a temporary. So this lunacy is of two types: a permanent lunatic and a temporary lunatic. So a temporary lunatic, so when he is actually not in his complete senses, you cannot enter into a contract. And even if you enter into a contract with him and he proves that he was not at all uh, able to understand, or it was a temporary type of thing, so that cannot be. Even when people are hypnotized, a person under the influence of hypnotism is also temporary unsound mind, because he will be totally in the influence of the person who is actually hypnotizing him.
Sir,
So at that time, any contract if is being entered into will not be acceptable, or it will be void. So mental decay brought by old age or disease also comes under this definition. Okay,
sir,
so a person who cannot understand the things because he is now means old enough to understand the things. So that old age or disease or something like that will also come into this definition, because he is not at all of a sound mind.
sir,
He is not capable of entering into a contract. Yes,
hello.
anything?
सर मैं पूछ रहा था जो
Yeah,
ड्रंक होगा,
थोड़ा जोर से बोलो.
सर जो ड्रंक होगा, अगर अगर एग्रीमेंट उसमें ड्रंक जो सोबर नहीं होगा वो, तो बेसिकली उसमें साइन तो करवा लिए एग्रीमेंट पे.
नहीं, साइन वाइन करवा लो, बट द थिंग इज दैट देयर हैज टू बी, अगर अगले पर्सन के पास में if he is having a reason of belief, or if he can prove to the best of his thing that yes, I was not at all in the senses when the signature was done, or otherwise. Yeah, one more thing is there. Somebody cannot say okay, अच्छा मैंने पढ़ा नहीं था, अच्छा I ignored it, तो मुझे तो समझ में नहीं आया. So these things will not work. But at the same time, a person who cannot understand the things, then no, this soundness and unsoundness will matter. And if a person is having a sound mind but he ignores the law at that time, then so the other person will be held, because ignorance is not an excuse of law. Sure, yeah, I hope you understand.
Yes, sir.
Yeah. So I think you have only asked this question.
No, sir.
Who asked this?
गौरव.
Yeah, Gaurav. Got it?
Yes, sir.
Fine. So any confusion? Anything related to this? चले आगे चले अभी?
Yes, sir.
Okay, thank you. So agreement by a person of unsound mind are void, but for necessities. Again, the thing same thing applies with these people also. आप कोई टल्ली आदमी, उसको आप घर छोड़ के आओगे और आपका पैसा लग जाता है, तो उस टल्ली की स्टेट से आप ले सकते हो. ओके, समझ में आ रहा है ना? But necessity applies to lunatic, to any member of his family. The lunatic state, if any, will be liable. So there is no personal liability incurred by the lunatic, but personal liability incurred नहीं हो सकता. You cannot just make him responsible to do certain things which you want. Okay, so specific performance of the contract मतलब ये होता है कि when that person only can do it. So if the state can pay, then it is okay. अब वो आदमी जो टल्ली है, उसके घर बार तो कोई है ही नहीं. अभी आप कहो कि मैं इसकी प्रॉपर्टी से वसूल लूं, तो if he is not having property, you cannot just recover anything from him. Okay, got it? Gaurav, got it?
Yes, sir.
Yeah. If a contract entered into by a lunatic or a person of unsound mind is for his benefit, it can be enforced. So whosoever is in the benefit, this is again a case of Jugal Kishore versus Chedu. Okay, so if the things are in the favor of lunatics, if the things are in the favor of minors, that can always be enforced. Fine. So next is the other person with the incapacity is a person disqualified from the entering into a contract. So some statutes disqualify certain persons governed by them to enter into a contract. For example, Oath Land Revenue Act provides that where a person is in oath is declared as a disqualified proprietor under the act, he is incompetent or alienate to his property. So there may be certain, you can say, for example, our constitution also says that any ambassador of any other country, for example, ambassadors are coming. So I think next are the ambassadors also are there. No. So ambassadors of any other country coming to India will be incapable of entering into a contract, because in case if they enter into a contract and if a suit is being filed against them, then there will be a problem. What problem? They may have to face the consequences, they may have to face the court, and ambassadors in India are considered as our guests. Any foreign ambassador coming to India will be considered as our guest. So in that case, you know, that person who is a guest and he will be subject to filing a suit and wo court ke chakkar laga raha hai and all that, so that actually deteriorates the image of the country. That's why those who are the foreign ambassadors, they cannot enter into a contract with anyone. So that actually determines their incapacity to enter into a contract. Okay, next is your alien enemies. Okay, so what are alien enemies? A person who is not an Indian citizen is can be an alien enemy. Alien can be maybe either an alien friend or a foreigner whose sovereign or a state is at peace with India, has usually contextual capacity of an Indian citizen. On a declaration of war between his country and India, he becomes a alien enemy. A contract with alien enemy becomes unenforceable on the outbreak of war. Otherwise, you can go. So alien, who is alien? Alien is whosoever is not an Indian citizen, and a person who has who is every person will be citizen of at least one country. So a person who is not a citizen of India will be alien, and when he will become enemy, when there is a war broke out, and if the war is broke out, you cannot enforce the agreements with those countries with whom the war has been broken out. So for the purpose of civil rights, an Indian citizen for the subject of a neutral state who is voluntarily resident in hostile territory or is carrying on a business there is an alien enemy. Trading with an alien enemy is considered illegal, being against the public policy. So even if an Indian citizen of a subject of neutral state who is voluntarily resident in a hostile territory, for example, somebody from India is voluntarily residing in or carrying on in business in Pakistan, he will also be considered as an enemy because it is his wish to just go over there and do the business, and it is his wish to just carry on his business with some with that country in which India is having the war against. So he will also be considered, may he be an Indian citizen whatsoever. Okay, so even trading with an enemy is considered to be illegal, and it is against the public policy also. So anything, any contract with alien enemy will not be executable. Okay. So foreign sovereign and ambassadors, I have already told you, foreign sovereigns and accredited representatives of foreign state, that is ambassador, high commissioners, they enjoy a special privilege that they cannot be sued in Indian courts unless they voluntarily submit to the jurisdiction of the Indian court. So nobody who will do it, nobody will does it, that I'm just allowing you to file a suit against me. Okay, so foreign sovereign governments can enter into a contract through agents. Now what will they do if they have come to India and they need something to eat? So when they will be going with the on the grocery shop, for sure they will pay some amount and there will be a contract between him and the grocer. So they can enter into contract through their Indian agents or agents residing in India. In such case, the agent becomes the personally responsible for the performance of the contract. So that in that case it is there. Next is a professional person. In England, barristers at law are prohibited by etiquette of their profession from suing for their fees. So this is not in India actually. So a person who is a barrister at law, or you can say a lawyer, out of his etiquettes of his profession is actually he cannot sue for his fees. Suppose for example he has fought some case from for someone, and he couldn't recover his fees, so he cannot file a suit for the fee. So also are the fellow and the members of the Royal College of Physicians and the surgeons. Doctors can also cannot file a suit for their fees, but they can sue and be sued for the claims other than their professional fees. In India, there is no such disability, and a barrister who is in the position of an advocate with liberty both to act and plead has a right to contact and sue for his fees. So particularly this thing is not applicable in India, but it is applicable in the England. So there is lot of difference between the English Act and so while we are going through this, we are able to understand and know the difference between the Indian law and the English law. And the Indian law seems to be more, more reasonable than the foreign law itself. Next is a corporation. A corporation is an artificial person created by law. That is just like a company which is registered under Companies Act. Okay, public bodies which are created by statute, such as Municipal Corporation of Delhi, अपना Jaipur JDA, Jaipur Development Authority, something like that. So a corporation exists only in contemplation of law and is having a no physical shape or form. So Indian Contract Act does not speak about the capacity of a corporation to enter into a contract. But if proper property in but if properly incorporated, it has a right to enter into a contract. It can sue and can be sued, and in its own name there are some contracts to which the corporation cannot enter without its seal, and others are not at all. So a company, for instance, cannot contract to marry. So this is what the thing is. So you cannot just compel a company to marry, or you cannot tell that okay, marrying with the company will be the marrying with the director itself. So it is not there. So further, its capacity and the powers to contract are limited to its character in the memorandum of association. So any contract beyond such will be ultra vires and will be treated as void. So what is there? So whenever a person is required to enter, or whenever a person is has to enter into a contract with that particular company, so it is the duty of that person to see the memorandum of association and articles of association of the company, and it will be his responsibility to ensure whether the company is capable of entering into a contract or not, or otherwise he will be in problem because the contract will be declared as void. Next are corporations. So corporations are also artificial person created by law. This is, I think we have gone through. Yeah, yeah, this is a repeat one. Sorry. Next is married women. So in India, there is no difference between men and women regarding the contractual capacity. Women married or single can enter into a contract in the same way as the man. She can deal with her property in the manner she likes, provided, of course, she is major and is of sound mind. Now, under English law, before passing of the law reforms married women and Tort Feaser Act 1935, a husband was responsible for all the acts of his wife, and his liability no longer the wife's liability no longer arises unless the wife is acting as a husband's agent. Now, therefore, even in England, the married woman has a full contractual capacity and can sue and be sued by her own name. So this is not applicable in India. But in case of India, there is one more thing which is called Parda Nashin women. Parda Nashin women is actually a woman who actually doesn't comes out of the Parda. Actually, he is not at all related with what is going on in the world. So this is something which is for each and everything for her act. Her husband will be responsible. So in India, there are still some areas in which such type of things are there, and the women will not be held responsible directly. It will be the person, or it is the husband of that woman who will be held responsible for all her acts. So in that case, it is there. Otherwise, this is no more existing. But still, as it is given in the law, it was required to be discussed. This was all about the contractual capacity which we have studied now. Any question, if you have, you can ask it to me. Yes, anyone? ये प्रकाश चौधरी, you have put your बचपन का फोटो लगाया क्या? प्रकाश चौधरी, है ही नहीं, absent. Okay, so this was all about. So let me take your attendance because I think our time is already, we are 5-6 minutes up. So Chandresh Kumar Sigar, Drishti,
Present, sir. Present.
Gaurav Agarwal,
Present, sir.
Gautam Godra, Arshad,
Yes, sir.
Kartik Rajput, Laksharaj,
Present, sir.
Yes, sir.
Atul Swami,
Present, sir.
Parth,
Present, sir.
Prakash Chaudhary, Pushpendra Pal Singh,
Yes, sir.
Rahul Jevaria,
Present, sir.
Rakesh Raika, Ravi
Present, sir.
Raman,
Present,
Mohammad
sir.
Yes,
Sameer,
sir. Yes, sir.
Shaurya Dikshit, Soumya Deepa, Teertha.
Present, sir.
Present, sir.
Present, sir.
Yeah, Soumya Deepa, how was your experience today?
Sir, it's fine, sir.
Sorry?
I can understand the subject also. I can understand the topic you're teaching, so it's
You
fine.
were?
I can understand what you're telling, so
Okay, that's very
it's
good.
fine.
So there are certain presentations also uploaded there. The presentation which has been uploaded is very, very colorful. Okay, so you can just download that presentation. You can go through those presentation by your own. Actually, what the thing is, the course is very long and we have less time. So sometimes I have less time to discuss some examples with you, but the text is always available, and even you can refer to CA module. I am teaching from CS Company Secretaries module. Okay, so this is for your information because everyone knows it. I thought I should tell you this, right? So you are most welcome, and I'm sorry
Thank you,
that
sir.
you were not able to. I was not able to take you in
It's okay,
before.
sir. No problem.
Yeah, but don't worry, you will not lose your attendance. Whatsoever is there,
Sure.
you will get. Okay. So
Okay.
actually, it is not my habit to detain anyone. But if somebody will never turn up in the class, then there will be a problem. Otherwise,
Yeah,
we
sure.
all are there. So till date, I have a history that I have not detained anyone in last 6 years of my over here in Manipal. So, but the students get detained if they do not come. So I do not detain anyone, but students get detained. What I can do? So it's like that. Anyways, so you are most welcome, and let us just have good interaction with you in the rest of our classes.
Yes, sure,
So
sir.
thank you all, and have a nice day. Bye bye.
Thank you, sir.
Bye, sir.